Well, welcome everyone. We're just waiting for the room to fill up with all the attendees. But while that happens, I want to welcome you all to our webinar today on employment in the new COVID era and what's going on and the changes that everyone needs to be aware of. I'd also like to thank our panelists, Christina Jepson from Parsons Behle and Mike O'Brien from Jones Waldo, for agreeing to participate and putting housekeeping stuff. Mike is going to begin. He'll speak for about 25 minutes and there will be 5 minutes for questions. And then Christina will follow him, speak for another 25 minutes with about 5 minutes of questions. And both panelists have agreed to stay after if the questions start to pile up and they're not getting answered. Please use the question and answer function at the bottom of your screen to ask the questions. And if there's a question that you particularly like, click on that and it will rise to the top and we can make sure that the questions that most people are interested in can be answered first. So once again, welcome everyone. The room is still filling up, but we do have a lot to cover. So I think we'll start and be able to get caught up pretty quickly. So Michael, with that, I'll turn it over to you.
Great, thank you very much, Lori. Let me go ahead and share my screen. Hopefully everybody can see that. Good afternoon, everybody. We very much appreciate you joining us today. We appreciate the opportunity to speak to you. Hope everybody's doing well. It's been a strange couple of months for the practice of law and for pretty much everything else. But we'll get through this together, as everybody's saying, and both Christina and I wish you all very well, of course. Today we're going to talk about employment issues and the pandemic. And those of you who are lawyers, proud alums of the University of Utah, you may remember about this time of the year taking law school exams and doing a lot of issue spotting. Well, there's so much information available on employment law right now during the pandemic that's the best that Christina and I can do right now is a lot of issue spotting. So that's what we're going to do. The slides contain a lot of information, more detailed information, and we'll both, again, stay to try to answer questions afterwards. I'm going to cover the first three topics: furloughs and layoffs, unemployment compensation, and liability for COVID contracted at work. And then Christina is going to cover the remaining three topics, a whole new series of laws on how to deal with employee leave issues, return to work issues, a whole series of important questions for employers, and she'll do a wonderful job updating us on all of those things. So without further ado, I'll move on to our first topic. I should note at the beginning that I'm a defense side, a management side employment lawyer, so you're going to see that sort of perspective come out as I present this. This is a presentation that I largely give to employers, telling them how to deal with the new laws and deal with the risks that come with a whole wide variety of issues that arise during this new COVID era. So that's my perspective. The information, of course, applies to large and small organizations, and certainly hopefully would be interesting and helpful to employees and their perspective as well.
And so, Mike, if you can start the slideshow, we're seeing your whole PowerPoint window. So if you can just hit from current slide up in the top corner.
How's that? Can you see it now?
Now go up to the top and choose display settings and switch presenter view and slide view, and then we'll be all set.
There you go. As you can see, we're all learning a lot of skills. And one of my skills is how to screen share. So at least you haven't received pictures of my dog or kids yet. Hopefully it's more substantive than that. And please tell me if you if I'm screwing this up somehow, because I don't want to walk around, like I've said before, with lettuce in my teeth. So we start with a sad topic, rather. A lot of employers who are impacted by this current situation have had to make very tough decisions to let employees go, either permanently or on a temporary basis. And Christina and I have fielded a lot of calls from employers asking how to do that, how to make those very sad decisions and difficult decisions. We expect, by the way, another wave of that could occur when a lot of the paycheck protection loans run out sometime in June here. And so we're hoping for the best, but fearing there could be another wave of furloughs and layoffs. So we wanted to start the presentation with a brief discussion about that and dealing with those issues. What's the difference between the two? Surprisingly, I get this question a lot. And it's really a pretty simple distinction. Furlough is a leave where somebody still remains an employee. They usually go on leave without pay, so the employer can save money, can save labor costs, but they remain employed and on the books. A layoff, of course, is completely different. A layoff, the employment ends, and there's a termination of employment. Each situation is similar in effect to the employee, but they have different legal implications. So here's a quick checklist of the legal issues, again, on an issue spotting basis that come up with furloughs. Number one, benefits. An employer needs to check with its healthcare provider to determine if and how it can keep an employee on healthcare benefits, for example, during a furloughed period of time. And that's an important issue to the person who's furloughed. It may well be an important cost issue for the employer to determine. Unemployment compensation. Not an expert in that area, but I do know a little bit about it, and unemployment compensation is available to employees who are furloughed. So an employer, of course, needs to understand that point and understand that concept when they're trying to determine whether a furlough will save them money. Wage and hour issues arise. So if you have an employee who is furloughed but is still doing some kind of work, they may well be entitled to pay, certainly for the work they're doing. But if they're what's known as a salaried exempt employee and they're doing work during any week, then they may be entitled to pay for that entire work week. So you need to issue spot that at that point and make sure you're handling that appropriately. The big issue for layoffs, of course, and furloughs both, is who is selected and how. The most risk for an employer comes about when somebody who has been furloughed or laid off is selected and believes that they were chosen for some inappropriate or illegal reason. And I'm going to talk about that in a few more moments in more detail, but we'll issue spot it for you right now. And then an issue, of course, that Christina will cover a bit later is when you furlough people, how do you bring them back safely and legally? And she has a wonderful presentation on that issue. For layoffs, again, you'll see similar points on the checklist, the general checklist for legal issues that occur during layoffs. But again, given the different nature of a layoff, there are different issues that arise. Because employment is terminated, you need to make sure that you're, as an employer, undertaking all of the things that have to happen when an employee is let go. Termination pay within 24 hours as required in Utah, different with other states. COBRA may be an issue, giving individuals COBRA notices for their benefits, et cetera. Unemployment compensation is again available for layoffs, just as it is with furloughs. So that's going to be an added cost to the employer that has to be calculated as part of your determination of whether you're going to save money actually by laying employees off. And then who is selected and how? Again, and we talked about this a bit with furloughs, that's where you see a lot of the liability risks and the liability issues appear, is on the question of who was selected and why and how. Notably, somebody who was selected for layoff may well point to another individual and say, I don't think it was fair that I was let go. I think it was discrimination that you kept that person and didn't keep me. That's typically where I see litigation and claims and difficulties for employers in the area of layoffs. So I want to spend the remaining amount of time I have talking about furloughs and layoffs, giving you very quickly the top 10 tips I think you need to consider when dealing with a furlough or a layoff to minimize legal risk. So number one, again, is probably pretty obvious, but involve your professionals. If you're an organization that has human resources, your HR professionals are going to know how to do this. They're going to know how and when to contact a lawyer to get help. They're going to understand the implications that arise from a layoff. They're going to guide you on the process. And without being too much of a promoter for the excellent services of Christina and myself, I think it's often good to get your lawyers involved. Maybe you have an in-house legal department, but lawyers, despite the often negative reputation, an unfairly negative reputation that we have sometimes, I think we more often than not add value. And this is certainly an example of an area where a lawyer involved up front can add value and try to minimize risk for an organization before the risks are already there and facing you. So be proactive, involve your professionals. That's the first point. Number two, somebody once told me don't put more than 8 words on a PowerPoint slide. So I apologize to that person for violating that rule so blatantly here. But document a reason for the layoff. Now, again, in this world where we're all COVIDians now, right, we have a reason, right? There's this pandemic, it's impacting our businesses. We've had to close, perhaps we have a decline in revenues. Whatever the reason might be, I think it's important to document the general reason why the layoff is occurring in case you need to use it later, but also as a tool to guide you and make sure you're only engaging in layoffs or furloughs for legitimate business reasons. So document the general reason. Step number 3, figure out how you're going to pick people for the layoff, right? You don't want some sort of Alice in Wonderland off with your head process going on here. You don't want some sort of random wonder world. Generally, there's 2 ways to do it, I see with businesses. You either eliminate positions that result or that are obviously impacted by the general reason for your layoff, or you reduce your headcount. So let's say, for an example, a law firm was heavily involved in representing restaurants. And during this COVID era, obviously, many restaurants are closing. Hopefully, they'll come back, who knows? But there's a huge decrease in work for that law firm. And so that law firm may decide we're going to have to eliminate positions of lawyers who do restaurant work. So you have a pretty clear choice of who's going to be laid off. It's those jobs that are impacted by the specific business condition at issue. Often, however, though, an employer will choose to do a reduction in headcount to say we have such a smaller income stream that we're going to have to reduce 20% of our headcount, 20% of our FTEs, our full-time equivalents. And in that situation, you have to do what I call the compare and contrast. You have to pick and choose among people, and you have to pick a way to make that choice in a legitimate business manner. Are you going to do it based on seniority with the company? Are you going to do it based on a set of job skills that you rate and rank? You have to figure that out in advance and then go through and implement that, so you sort of score employees and rank employees in a way that provides you with a legitimate business analysis as to how to let them go. And that's where a lot of the fighting comes about later, right? Where Mike O'Brien is let go and Christina Jepson is not, and Mike O'Brien's very upset about it and says, aha, you must not like bearded Irish Catholic lawyers, and that's why you did it. And so I bring a lawsuit. So that's typically where you see the action in employment litigation, and you can minimize that risk by having a good reason, a good selection process, and documenting it carefully. So step 4A, again, if you eliminate the positions, the lawyers who do restaurant work, you just document which positions are being let go and why. Step 4B, if you're picking and choosing among employees, you want to put together some sort of a spreadsheet, a grid, an analysis, a scoring, however you're going to do it, that explains why you're picking and choosing and who's going and why. In employment claims, you can defend a discrimination issue by showing you have a legitimate business reason for why you did what you did. And this step 4B helps you develop that reason. So number 5, it's always good to have somebody looking over your shoulder, right? To have someone second guessing you, right? If we didn't have that here, I would be obliviously giving this presentation without having shared my screen appropriately. So thank goodness for people who look over our shoulders. And you want to have that in a layoff process too. Have a neutral third party review it, review the selections and the way you do it to make sure it's not singling out people based on some sort of a protected class. Again, another protection network for you as an employer. Step number 6, look at the ones, the selections that raise red flags, right? Or a disproportionate amount of whistleblowers being chosen, a disproportionate amount of women being chosen. Is everybody who was chosen over 40, or is everybody who was chosen someone who recently took ADA or FMLA leave? Those flag problems for you. Now, they may be legitimate choices that you can justify as an employer, but you have to understand that those are higher risk choices, and you need to document the selection and make sure that you can show a legitimate business reason for why you did what you did. Step number 7, again, make sure it's not a sham. This is a bit of a second guessing one as well, but I often have employers call me and say, hey, Mike O'Brien isn't performing very well and I want to get rid of him, but I don't want to confront him with this unhappy news of his poor performance, so I'm just going to lay him off. Is that okay? And, you know, as Christina and I will answer if you ever ask us that, no, that's a problem, right? If you want to be truthful and accurate in why you're letting somebody go, and using a made-up layoff scenario to let somebody go based on performance reasons can typically lead to problems for you down the road if you get challenged on that particular decision. Step number 8, communicate. Right? Communicate the decision to the individuals impacted in a clear and courteous manner. Recommend you avoid engaging in debate. There's never going to be a situation where you'll go to somebody and say, Mike, we're letting you go as part of a RIF, and I'm going to say, hallelujah, I'm long overdue. You should have picked me years ago, right? It's going to be very impactful for the individual who's chosen. And so you want to find a way to communicate clearly and courteously without debating them about it, and respect the dignity of the individual. Don't add insult to injury by treating them poorly, as you're also letting them go out the door on a layoff. Number 9, I see a lot of litigation from what I call backdoor transfers that occur during a layoff. So, you know, you pick 10 people for layoff, but you let 9 of them transfer to other jobs, and the one person you don't let transfer to another job is your over 40 individual who's in numerous other protected classes. And so why didn't that happen? Why wasn't that person given the opportunity for a backdoor transfer too? So watch out for the risk of doing a careful selection process, but then undoing it by letting all this behind the scenes action occur that might look like it's favoritism or discrimination. And then last but not least, severance pay. Severance pay and release claims, a very, very good way to limit your risk and your potential liability in layoffs. There's a lot of tricky issues that come with doing severance pay in a layoff situation. If your employee is impacted or over 40, then you have to go through certain steps outlined by the Federal Older Workers Benefit Protection Act. And those steps are different when there's a group of people being laid off as opposed to simply one individual. So you need to make sure your release agreements comply with the applicable federal and state laws, because if they don't, you may pay an employee a lot of money to go away and sign a release agreement only to find out that it's not enforceable. And that would be a very sad situation for an employer as well. And potentially quite sad for the lawyer who advised the employer on that situation and didn't tell them about these particular requirements. So 10 steps, very quickly, very shortly, issue spotting as to how you can minimize your risk during a layoff. Implement them if you have to be involved in that. If you're advising clients about that, make sure they're aware of those steps and they look carefully at them as they're implementing layoffs, either in the next wave or in the future. So let's shift gears to unemployment compensation. And again, I need to give you a disclaimer. I know something about this, but I don't typically practice in this area. I actually appeared for a client once in an unemployment compensation hearing and realized very quickly that the only thing I was doing was annoying the hearing officer who was going to decide the case. And so a lot of this work is done without the active involvement in lawyers, so I know a little bit about it. But luckily, we have some very good resources to help us on the issue. The Department of Workforce Services has a number of links. They have a special COVID page. They have a specific page where you as an employee can click on it and answer a series of questions to find out whether or not you're eligible even for unemployment compensation in the COVID era. So I want to commend those pages to you, recommend that you look to them carefully. I will note that it is available for both layoffs and furloughs. So, you know, if you as an employer think you're going to save money by letting individuals go or by furloughing them, you may have an impact in terms of the sort of costs you have to bear of an unemployment compensation claim. So check into that issue carefully. Check into the website carefully. Thank goodness it's there, right? A lot of us as employees have been severely impacted by this, either ourselves or our family members or our friends, and it's good to have that bridge that's available there. But there are some technical legal issues that the Department of Workforce Services can be of great assistance with. The interesting question that I find that clients are asking me, and I'm sure Christina is getting these questions too, is what do I do with somebody who refuses to come back to work because they're making more money on unemployment compensation than they are from their job? That's you know, certainly an incentive that was put in place by Congress and by the states, and it's good that it's there for employees. But as a general rule, and again, you have to look at the specific circumstances to know for certain, but as a general rule, somebody who declines to come back to work because they want to stay on unemployment compensation is going to put their unemployment compensation at risk, right? Because refusals to work are a disqualifying factor generally for unemployment compensation. And employers have a duty, as does an employee, to report that work has been offered to an individual, but it's been turned down, which will then trigger a reassessment by the Department of Workforce Services about whether or not continued benefits are available to that employee. So more information on the slides, more information on the website, of course, but if you're dealing with employees who refuse to come back to work, that's going to have implications for them. You can advise them of that. And if they don't come back to work, you can terminate your relationship with them. Employer liability for COVID contracted at work. This is a fascinating issue. And again, I think we could spend almost our entire hour talking about this alone. Christina and I have had some really interesting discussions about this, preparing for this seminar. But it's a fascinating question. If I let customers, if I let visitors back in my office or my business, if I let employees back and they catch COVID there, am I going to be held liable? The Utah legislature has tried to answer that in a couple of different ways. So number one, they passed in special session, by the way, in a Zoom special session like this, they passed HB 3007, which creates a rebuttable presumption that responders and healthcare employees who get COVID-19 got it while they were working. So those individuals are able to apply for for workers' compensation and eliminate, for all intents and purposes, the causation issues that might arise as to where they caught the virus. That's one way the legislature's tried to handle the issue. But the other is through the passage of SB 3007, which is an immunity statute. And there's a link right here to the statute. You can review it for yourself. Essentially, it says a business is immune from suit for individuals who contract COVID-19 there unless they acted willfully, recklessly, or intentionally to get somebody sick. Now, this law may be challenged. It may be subject to some sort of a discrimination claim. It may be subject to challenge under the Utah Constitution open courts provision. But for now, it's the law of the land, effective as of May 4th, signed by Governor Herbert. The question of how it impacts employees is not completely clear. The statute does say that it does not modify the application of the workers' compensation laws. And if you listen to the legislative history, it's made clear that the sponsors at least seem to think anyway, that people can still file workers' compensation claims with their employer despite the passage of this statute. Now, just because you can file a claim, of course, doesn't mean you're going to win it. And there are provisions within the the workers' compensation statutes that deal with causation issues, that deal with mitigation issues, that deal with allocation of causes for a particular condition. And so the advice I'm giving my clients is if you have an employee who claims they contracted COVID-19 at work, you should pass it on to your carrier, to your workers' comp carrier. We're insured for that. We have that sort of insurance, and let the carrier, who are experts in this area, work it out, make the decision on your behalf, and trust in how they're going to do that. I looked at the website for the Workers' Comp Fund of Utah, which again is one of the main carriers in Utah, and they seem to suggest that very advice as well, indicating the facts of the circumstances of the specific situation are going to govern whether or not workers' compensation is available. So again, in a nutshell, that law still seems to apply. Refer it to the carrier, let them decide. We've had a test case, by the way, on the immunity statute brought already. On May 15th, the Tribune reported that an American Fork company was named as a defendant in a lawsuit by an employee who alleges that the employer engaged in willful misconduct that caused her to contract COVID-19 at work. So, again, 90% of lawsuits settle, so we may not actually get much information out of that lawsuit, but it'll be interesting to watch it and see if the courts give us further guidance on what the immunity statute means, and give us further guidance on whether or not it's constitutional, how the workers' compensation provisions play into all of that. Stay tuned. Exciting news ahead, hopefully. the best advice we can give you to minimize return to work issues, people who contract COVID returning to work, is to listen carefully and closely to what Christina's going to tell you in a few minutes about everything you should do to minimize your risk about return to work, specifically following OSHA and CDC guidelines. That's probably going to be the standard to measure whether or not you've engaged in reckless or intentionally misbehaving behavior. So I think that's I think that pretty much takes care of my time. We do have a few moments for questions. Lori, I don't know if any have been posed.
Yes. Let me ask this one, Mike. When you're communicating the termination news in the pick and choose context, how should you deal with the question from the employee about why he or she is being let go?
Yeah, great question. Answer that question with great courtesy, with compassion to an individual who's in a hurting situation. Again, I don't think you want to go into great detail about that. I think you might, in a sentence or two, explain your selection process. You know, you were chosen, Mike, because you do restaurant work and we don't have any more restaurant work available at the law firm right now, would be an example. If you've used a series of factors, you might say, you know, we, in a layoff, we always let people go who we wouldn't let go in normal circumstances, but we did look at special skill sets and individuals who can best serve our needs going forward in a very difficult environment. And unfortunately, you weren't one of those individuals who ranked high on that criteria. So we're sorry, we wish you well, and we hope you'll consider this transition pay that we're offering you and as a way of helping you move on. Again, you know, you want to wordsmith that a little better than I just did on the fly, but I think you want to focus on compassion, very short and brief explanations for the reasons, and then focus on where you go from there.
Thanks. Another question. How do you go about calculating how much unemployment compensation will impact the employer?
That's a great question. That's a question I would refer to the experts at the Department of Workforce Services. I'm not an expert on that sort of calculation. So I would good luck trying to reach them. They're so busy right now, but I think they're the best source of information for that.
Okay, here's a question that's addressed to Christina, but I'll lob it out to both of you before we move on to Christina's portion. When employees return to work and have disclosed they were in hotspots of COVID-19 or had COVID-19, are employers allowed to ask for documentation you have received a COVID-19 test, and can they keep this documentation on file?
I think it depends on the situation. If I had someone who said they had been to a hotspot, oh, I'm sorry, go ahead, Mike. I was gonna say, no, if I had an employee who had been to if an employee had been to a hotspot, I would probably ask them to quarantine for 14 days and not come into the office. If someone actually contracted COVID-19, they shouldn't come back to the office or to the workplace until they've met the CDC criteria, which is to be symptom-free for a period of time or have documentation from their healthcare provider that they can come back to work. And I'm going to talk about that in a slide in the future.
All right, well, I think that you've heard enough from me, so we can transition over to Christina.
Okay, great. Is my screen sharing okay?
Yes, it looks great.
Okay, terrific. So I'm going to talk about quite a bit, and just as Mike indicated, there's so much material here that I'm really just going to try to issue spot, let you know some of the issues that are out there, and if you need more information, contact your in-house counsel or your outside counsel for more information. Of course, as with Mike's presentation, it's general information. It is not legal advice. You really have to talk to your lawyer if you have specific situations. Okay, let's first talk about leave and the Families First Coronavirus Response Act. This was one of the first pieces of legislation that Congress passed when the coronavirus came, into our country and started impacting our country. And it was really an attempt to make sure that employees would have a way to take leave and receive pay. And really, it was the government's way of basically funneling these funds through employers. And yet, in a way I'll explain, employers don't ultimately pay for this. So how it works is it's a much expanded leave than we're used to in employment law, or if you're an HR professional. This leave applies to all employers with less than 500 employees, with some very limited exceptions. So I know we're used to generally these kind of laws applying to bigger employers. This one's kind of the opposite. It applies to everyone with less than 500 employees. And if you're in that category, you have to make sure that you're putting up the poster that the federal government has issued. And I would suggest also having a policy about the leave that has to be provided. Now, there are a couple of buckets of leave, and I'm going to talk about both of them. First of all, I'm going to call it the bucket one leave rights. This is basically sick leave pay that you have to provide to an employee in a variety of situations, which are listed on this slide. So this could be because they're under a quarantine order, they've been ordered to self-quarantine, they have symptoms of COVID-19, and they can't just say they think they have symptoms. They have to have symptoms, and they have to be seeking medical diagnosis, or if they're caring for a family member who is, subject to one of these orders above. In one of those situations, if they provide, the proper explanation, they're entitled to sick leave pay. Now let's talk about bucket two leave rights. This is basically parent leave. So as we know, a lot of daycares have been closed, schools have been closed, people have had very serious daycare issues. If they're in one of those situations, they are entitled to this leave, and again, it has to be paid. And this is so different than what we're used to with FMLA, where it's not paid leave and it only applies to bigger employers. Very different. So there are some limitations. The bucket one sick leave pay, you do have to pay them 100% of their leave, except that it's capped at $511 a day and a total of $5,110. Bucket two parent leave, you pay them 2/3 of their pay, capped at $200 per day, $12,000 total. Again, these eligibility requirements are very different than we're used to. Bucket one applies immediately. If you hire someone and they qualify for that sick leave, the second day they work for you, you have to give it to them. Bucket two leave, parent leave, you have to give to them if they've worked for you for 30 days. So it is much sooner than we're used to under FMLA, which is usually a year. So you need to have, there's a lot of details with this leave. It's best to have a policy, and there's some things you can do in a policy to make it better for the employer. So you want to talk to your HR people or your counsel about preparing a policy. Now you should know that for the most part, although you are going to be paying the employees for these leave entitlements, you're not ultimately paying. There are pass-through tax benefits for all of this leave. It's 100% reimbursement from the federal government through your payroll taxes. And that's sort of complicated how that works. But you have to keep records of the leave, and that someone truly qualifies for it, so that if you're ever audited for getting these payroll taxes back, that you're covered. So you want to make sure that you're doing this very carefully. Okay, now I'm going to turn to the next topic, which is return to work. Now, as you probably know, there are a lot of return to work guidelines. They come from the federal government, they come from the state government, OSHA, the CDC. You probably have industry-specific guidelines you're dealing with. So I'm not going to try to go through all of that. You need to make sure you get a hold of those and you understand them. But I'm going to talk about a few things that legally will help you. And this kind of goes back to Mike's point about, we're not really sure what the liability picture looks like. We don't know if employers are going to be able to be sued, if it'll be covered by workers' comp or not. Will there be liability? But the best thing you can do, not only to protect your employees, which is what you want to do, but also to protect yourself against liability, is make sure you have a really good process for complying with the guidelines and making sure that you're documenting everything you do. So I suggest that you set up a decision team, make sure that that team is completely tasked with finding out what the guidelines are that apply to you and implementing them at the workplace. find out what the relevant guidance is, have written policies and procedures that you can later say, this is what we did, and this is what we, we complied with. You need to make sure that your space in the workplace is completely prepared, that your people are prepared, that they understand what the rules are. This is a time for lots of communication. You want to make sure that what you're doing is being well communicated to visitors, to your companies, and to your employees. And you have to be able to react quickly. Things can change on a dime. We could go, back to orange to red very quickly. So you have to be adaptable, have contingency plans. This is a time for leadership. If you're telling people to wear masks and people at the top aren't wearing masks, then that's not good leadership. It has to come from the top down. You have to have good communication so that your employees have confidence to come to work and your clients and consumers have confidence to buy your products or services. They're not going to come into your workplace if they don't feel like it's safe. Documentation for all the reasons we've discussed so that you have a good record of what you've done, making sure that you're keeping individual situations confidential. That goes to that question earlier. If you do get information about a test or someone's health situation, that should be kept completely separate from other HR records. And this is also a really important time to keep the mental health of your employees at the top of your list. Everyone is under extreme stress right now, and you really need to look out for everyone's mental health. As you look at reopening or continuing to be open, you need to make sure that you understand how the Centers for Disease Control policies apply to you, how OSHA applies, state and local guidance, and you should also look at industry best practices. A lot of companies belong to an industry group. So Mike talked a lot about restaurants. If you're a restaurant and you belong to some type of restaurant association, they probably have some guidelines to help you with your reopening. So, be in touch with your industry groups to find out what they have in terms of opening plans. But of course, some of the main things we're going to be looking at are social distancing, cleaning, a lot of things that require careful implementation. So it's a good time to have your team that we talked about and some kind of workplace coordinator that is making sure that everything is followed. On the OSHA front, it's interesting, just a couple of days ago, OSHA sent out some new guidance and indicated they're going to be doing many more investigations of workplaces to make sure that COVID policies and procedures are being adhered to. So that's something they're looking at doing. In terms of OSHA, OSHA has always said, of course, that you have to have a safe workplace and you have to avoid hazards. And COVID-19 is a hazard and potentially makes your workplace unsafe. So they're going to be doing inspections, like I indicated, and they're going to be looking to make sure you're doing everything you can for employees. So, you need to look at your policies and procedures. As I indicated, you should have a policy about leave. You should have emergency plans, remote work plans. I would say a written protocol for cleaning, a written protocol for what to do if you have a positive test, a written protocol for testing temperatures, for screening for symptoms and exposures, and making sure that if anyone's not following those, that you're actually doing something about it. Maybe everyone's had the experience that I have where my family went through a drive-through to get an ice cream cone and the workers had masks, but their masks were hanging down on their chin, kind of like this. Well, that's not helping anyone and that's not complying with the rules. And they should be, that employee should be talked to. If they continue to violate the rule, they should be written up and they should be terminated if they can't obey the rules. That's really critical. In terms of other things that we're hearing from the guidance, we need to make sure that we're closing or strictly limiting areas where people could congregate. I'm suggesting that clients really look at their workplace by walking through from the point employees or customers park all the ways they go through the workplace and think about the places they touch, places where they might interact with people, places that need to be cleaned extra well, all those sort of things. Look for high traffic areas. Think about what you need to do about traffic flow and ventilation. These are all things we need to be thinking about now. In terms of cleaning, there's a lot of information from the CDC and some from OSHA as well about cleaning protocols. This is the time to think about hiring extra people or assigning people in your company to make sure those tasks are fulfilled on a daily basis. When we think about employees, vendors, and customers, we have to, of course, think about social distancing, that really important 6-foot distancing. And one option, of course, is to have people return to work in either phases or shifts, so that not everyone's working at the same time, if that's something you can possibly manage. Another really important benefit of that is if you do get a positive case and you've limited people to one shift, you might only have to take one shift off of work for 14 days instead of taking out everyone in the whole workplace. And that's another reason you have to have careful documentation about who has worked on what shift and who's been exposed to whom. One thing I'm really suggesting that clients do is a lot of training. You can't just tell this to your employees once. You have to tell them a lot. In fact, I'm suggesting daily safety huddles that have been very normal in the construction industry and the mining industry, and now should become normal in all kinds of workplaces. Now, of course, these aren't actual huddles. No one should be huddling together, but virtual huddles. But whether you're having a team meetings with everybody spread apart or you're doing it on Zoom, make sure on a daily basis or a weekly basis, you're going through the safety issues, talking about new things from employees about what's working and what's not working, and document those huddles so that if you ever have some issues down the road, you are able to show that you were talking about safety all the time and people knew what to do. Now, I'm going to just talk a minute about PPE and face coverings. I think there's a little bit of confusion about this. And one reason there's confusion is I don't think the state guidelines are perfectly clear about whether this is required or not required. I personally think that all employers should have employees wear face coverings anytime they're in some sort of public place in the workplace. So right now I'm in my private office, so I don't need to wear a mask. But if I walk outside of my door, I should have my mask on. That's my opinion. There are different kinds of face masks, and this first slide talks a little bit about how they should be worn. I think they should be provided to employees. There are surgical masks, which I'm sure many of us are familiar with, and there are N95 respirators. Now, for the most part, these are not required in most workplaces, unless you're in healthcare or certain manufacturing facilities, or places where you literally can't stay 6 feet apart. You might have to have something more serious. Otherwise, most work places just need to be looking at those cloth masks that are, pretty easily available now. And if you need surgical masks or N95s or cloth masks, you need to be thinking about obtaining those now. A lot of supplies are in low supply. So if you need hand disinfectant, if you need face masks, temperature thermometers, all those sort of things, you need to get them as quickly as possible. Okay, let's talk a little bit about screening. Very unusual. We really never seen a situation like this. And Mike and I have been practicing in the area of employment law for a long time. And I don't think we've ever before said, hey, why don't you take everyone's temperature at work, or ask them, if they went anywhere interesting over the weekend, or if they're feeling not so well today. That is so unusual. And yet that's the situation we find ourselves in. We have to use the limited tools that we have to try to keep this virus out of our workplaces. And we don't have a lot of tools until testing becomes universal. Until that time comes, we really just have to use what we have. And one of the tools that we have is to take temperatures, because of course a fever is one possible symptom of the virus. We can also ask people about other symptoms, and we can find out if they have traveled or been exposed in some other way. So, because we're really going back to this thing I've highlighted here, and that is that all of the relevant guidance is telling us that people with symptoms should not come into the workplace until those symptoms have cleared, because they're potentially dangerous. Now, that being said, a lot of people without symptoms still have the virus. That's why we do other things like wear masks and clean and keep people distant, because these are all just tools. You have to be non-discriminatory in using these tools. That means you're not going to just test some people. Management isn't excluded. We're not just going to test people who are over 60. We're going to test everyone who, is in some category that it makes sense to test. We're going to keep the medical information very confidential in a separate file, and make sure that that is not shared except for with people who really need to know. In terms of symptoms, this is something you can ask employees about, and probably should. Employers are doing this in a variety of ways. Some are sending basically a survey to employees to fill out before they come into work. Some people are using apps. Some people are just verbally asking or having policies that require employees to indicate if they have any of these symptoms. And just realize that they're changing over time. Initially, there were only a couple of symptoms that employers were looking at, and now the CDC has added more symptoms. So it's really important to stay on top of this. As the virus continues to spread, we're going to get more information about how it spreads and what symptoms are important to check for. I would really suggest that you have a written policy about temperature screening and symptom screening, and set a criteria in advance. You don't want to be deciding on the fly what constitutes a fever. Now, according to the CDC, a temperature of 100.4 or higher is a fever. So that should be at the very least the standard that you have. Some employers I've seen are going as low as 100, and you have some discretion there. I think it's appropriate to go to 100 and say anyone above that can't come to work. And then of course you have to be consistent and really apply that rule and make sure that they're sent home or they don't come into work if they have that temperature. We talked about symptoms and not coming back to work until you've been cleared. And then also exposure. It's appropriate to ask people about exposure. So this could be in that same survey, questionnaire, or just screening process that you do verbally with employees. Have they been in close contact with someone who's tested positive? Have they tested positive? Have they been to a high-risk area? In any of those situations, they've potentially been exposed, and they should follow the guidance about not coming back to work until they've been cleared. Now, a few things about temperature taking. It really depends on your workplace about how you're going to do this. Some employers are simply having employees take their temperature at home and not reporting to work if they have a temperature, or you might have to do it in the workplace, and you should try to get the infrared distance screeners right away if you can. I hear a rumor that they're more available than they used to be. I hope that's true. But obviously you can't try the day before to get this equipment. You've got to get on top of that right away. If you're going to have temperature taking at work, you need to make sure that whoever's doing it is trained, or if they do it at home, they need to be trained. They need to have access to the equipment. They need to know what the procedure is for letting their employer know if they have a temperature. If you're going to do it at work, it's great if someone already has some medical experience, if they can be the person. There are some people you can hire to come into your workplace and do this, or you could have someone at work be trained and make sure that they're up to speed on how this works. But who's ever taking the temperature, they need to be wearing protective gear because they're going to be potentially exposed to people who have the virus. So they need to be wearing masks, potentially a gown. The best case scenario for someone taking this temperature would be for them to be wearing an N95 if you can get a hold of those. And just like with everything else at work, you don't want to create a situation where people are congregating and not being socially distant. So having a temperature screening check-in area at the beginning of work where everyone gets together and gets in line and crams in and gets their temperature taken would be the opposite of what we're trying to achieve. So you, in a temperature taking situation, you need to make sure that people are socially distanced, there aren't crowds, you're cleaning just like you are with everything else. And you also have to compensate people for the time spent screening, or you're going to have wage and hour problems. If you're going to do screening at work for temperature, you could do it outside the workplace, which is what the CDC recommends, because remember, once someone comes into the workplace with a temperature, if they come in and they walk all around the workplace and then you take their temperature and you find out they have a fever, you potentially have to send everybody home. So it's much better if you can test them in the parking lot before they come in. You might do a drive-through. Some people are doing that. You could set up a special trailer. You could do it inside the facility, but as I've indicated, you want to do that as quickly as possible once they've entered. You don't want them walking through the entire workplace before you find out that they have a temperature. So those are some suggestions for doing that. If someone fails to pass either the temperature screening, other symptom screening, or exposure screening, they should not come to work. They should go home if they're already there. Figure out if they can do some remote work if possible. You're going to need to do follow-up with them, find out if they tested positive or not. Sometimes it's another reason they had a fever or another symptom. And then you also have to do a little bit of contact tracing. You have to find out who they were exposed to at work, and you're probably going to have to send some of those people home for a period of time. So you need to have a policy about this and figure out what's going to happen. In terms of returning to work, the CDC guidelines about when someone can return to work after having symptoms or a positive test are a little bit complicated, but I've included them on this slide. It's an either-or situation. They either have to have a period of time where they're symptom-free, or they have to have documentation from their medical provider. So you want to follow this very carefully and make sure people are not coming back to work unless those are met. Okay, sorry, we're clipping along really fast here, but want to get through a lot of material. The final topic I want to talk a moment about is protecting vulnerable persons. This is the same as high-risk persons. This is really, I think, one of the most important things in terms of successfully bringing people back to work without having a lot of problems and deaths and people hospitalized. The most important thing we can do is identify those high-risk individuals and make sure that they are protected. And this is a really complicated topic because it requires getting into some areas that, again, Mike and I would say don't normally ask about these sort of things. When we're talking about high risk, Utah describes that as 65 or older, although a lot of guidance says 60 or older. So, kind of keep those as either ors in your mind. And people with other conditions that make their immunity less strong or make them more susceptible to having really bad outcomes if they catch the virus. And even though I've listed on here the current list of diseases, this is another situation where the CDC is changing this all the time. So you want to stay informed about what those conditions are. And what Utah and other guidance are really telling us is that if people are in one of these high-risk categories, we should give them special accommodations. Now, this is another area where it's kind of gray because I can tell you exactly what it means under the ADA if someone falls under a category where they have a disability and what the law requires you to do in terms of interacting with them and seeing if you can accommodate them. This is a little different. Some of these people probably would qualify as having a disability and maybe others wouldn't. And yet Utah is saying you should, but I guess don't necessarily have to accommodate them. We don't really know what that means legally. So really the best I can say is you should try to accommodate these people. You don't want to have a situation where they're potentially going to bring a lawsuit or because they caught the disease or because they lost their job because you didn't accommodate them. So we have to do the best we can. And in terms of the law, you certainly can't just say, well, older people, we're just going to not have you, we're going to furlough you. You just stay home for a while because we don't want to take the risk with you. You can't do that with pregnant people. You can't do that with people with underlying conditions. That would all be discrimination. So what do? Employers are saying, what do we do? We're supposed to protect these people, and yet we can't tell them that they have to go home and not work. What can you do? Well, you should do everything you can if you have the ability to in your workplace to continue teleworking, allow flexibility. I have some clients who had volunteer programs in terms of who comes back to the workplace and who doesn't. You can have a policy that says employees can self-disclose if they want to, that they're in one of these high-risk areas, and then you can work with them in terms of what things can be done to make them safe. And of course, there's the leave that we talked about that could potentially apply. If employees do self-disclose that they're in one of these high-risk categories, I suggest that you treat it very much like you would an ADA situation. And in fact, it might be an ADA situation. And that is, you have an interactive process with them. You find out what you can do for them to make it more safe for them. You know, extra things that you could do in the workplace to make it safe, or allowing them to work at home. That's really, I think, the best we can do with this situation. Now, I sometimes am asked, and I'm sure Mike is asked as well, well, what if an employee refuses to work? And I always say, proceed very cautiously. You want to find out why they're refusing to work, because you might have that conversation and find out they're concerned about working because, in fact, they do have an ADA disability, or they do fall in a high-risk category. And in that situation, you really want to talk to them about what can be done to accommodate them. But if it really comes down to a situation where an employee is just scared and there's no amount of action you can take to make them feel better, you know, you might have to let them go. But again, you would want to do that very carefully and talk to counsel about doing that in a way that limits your liability. I have a few slides in here about a positive COVID test. You can look at those. You can do testing. I don't think testing is really available for employers for the most part. So for the most part, we're talking about employees getting testing on their own. If they do, you need to follow guidance about not revealing their identity, doing contact tracing to make sure other people are sent home who came in contact with them. That's why we talked about staggered shifts and the importance that can really, a really useful tool in this time to make sure that we're not closing down the entire workplace. And then, also having a really good plan about what you're going to do if someone tests positive. I've had employers call me with positive tests and really not know what they're supposed to do next. And one thing that's really hard is finding the resources to have someone come in and completely disinfect the workplace if you've had a positive test. It's important to know in advance what those resources are, who you can call if you need to have your workplace, really deep cleaned because of a positive test. So I think I'm out of time. So Lori, do we have any questions?
We do, and I will just go down the list. What about a hostile environment when a workplace reopens and some employees or supervisors dislike an employee wearing a mask or asking for physical distancing? Masks and distancing have been politicized. So what do you do to avoid, you want to wear a mask, but your employer says no?
Yeah, so employees should be able to wear a mask unless there's really some safety issue that prevents it. So, for example, I'm working in machinery where the mask could get caught up and it would be more unsafe for me to wear a mask than to wear one. Unless that situation exists, people should be able to wear a mask, in my opinion, and the employer should let everyone else know that they're entitled to wear a mask.
Okay.
Do you have anything to add to that, Mike?
No, I agree.
Do COVID-19 layoffs qualify for the WARN, unforeseen business exception?
You can take that, Mike.
WARN.
Yes, so I saw that question and had an answer in my head and went off video to double check it on my phone. And I think the answer is yes, that the unforeseen exception will apply. It's written in such a way as to refer to unexpected acts beyond the control of the employer. And it's hard to imagine a more unexpected act beyond the control of an employer than a pandemic. So I would think it would apply to WARN situations.
Okay.
I would say talk to your legal counsel because WARN does have a couple of exceptions that certainly may apply. The business exception where there's some really unforeseen business circumstances, and also I think it talks about natural disasters, which this may qualify as. But it depends on the situation. If you've known for quite a while that you're going to have to do a big layoff because of this pandemic, because it's been going on for a while, you might have to provide notice, or at least as much notice as you can. So talk to your legal counsel about doing that in the safest way possible.
Great. Next. Is there any way to speed up the process of getting the release from quarantine letter from the health department caseworker so we can bring negative test employees back to work more quickly than the standard 14 days?
Not that I know of.
Yeah. I saw this question. It's from one of the wonderful members of the class of '86 of the University of Utah College of Law. So great question. Cajole, beg, plead. You keep hearing all of the authorities say, when it comes to documentation, relax, right? I mean, normally Christina and I are going to be telling you, get documentation. But the healthcare industry is so overwhelmed right now that the conventional wisdom is be patient and back off. So I don't know of any way other than just to, contact them and tell them the urgency of your need and hope that works.
Okay. Can employers take into consideration whether a particular employee commutes on public transportation when making layoff termination decisions?
That's interesting. Well, I mean, you can consider as part of a layoff anything that's a legitimate business reason. And so if the fact of commuting somehow, can be documented as a legitimate business reason, then yes, you can use it. I think you'd want to be careful in that situation. I mean, for example, in Park City, a lot of the employees who do a lot of the labor-intensive work belong to minority classes, and housing is so expensive in Park City that it's very difficult for them to live there, so they have to commute. So I can envision a situation where commuting could be attacked as a ruse for some form of discrimination. So I think I would be careful on that reason and talk with legal counsel and make sure you can justify it on a non-discriminatory manner. Christina, what do you think about that?
Yeah, using public transportation increases your risk of catching the virus, but lots of things do. So I think just singling out one risky thing and not others, like you said, could be discriminatory.
Okay. Can you suggest that your employees take family leave, bucket 2, if the employer has concerns about keeping their employees or needing to lay them off?
Yeah, you can't make someone take the leave. I guess you could let them know that that's available. Some people don't know. So if someone, for example, had a lot of childcare issues and you're trying to reduce your workers, you could have that chat with them, but you'd have to do it carefully in terms of, letting them know that that's an available leave, but not forcing them.
Okay. Can employers require employees to wear masks?
I say yes. Yes. You can do a lot of things in your workplace. You can have lots of rules, right? Yes. I required Mike to wear one during this. You absolutely can require them if they want the job and you decided that that's something that you need to do to keep your workplace and your customers safe, then you can require it.
I agree. In fact, my employer suggested that I wear a full face mask to protect everybody from various other factors that are unpleasant too.
Is there a penalty for allowing an employee to return to work before they have a written release? That gets back to the documentation question. Is there a penalty if you let them come back to work before you have the written documentation that have been cleared?
Well, I don't know what they mean by penalty exactly, but the CDC has the sort of either or. They can come back when they, sort of met the symptom-free guidelines or they have medical documentation. If they haven't met one of those scenarios and you let them come back to work and other people get sick, you're going to get sued. So I guess that's a penalty.
Okay.
What do you think, Mike?
Yeah, that's a pretty big penalty. That if you look at the complaint for that company in American Fork that was sued recently, I mean, part of what they're accused of doing is that sort of, recklessness in terms of how they manage the return to work process. So, I mean, I think that's a pretty big penalty, and the best way to deal with it and minimize it is to pretty carefully follow what Christina has said employers should do.
And think about this scenario. I mean, this is so different than we're usually dealing with at work. But say you force someone back to work quicker or let them back to work quicker, and they expose other people get sick, those people take it home, and their grandmother dies or their child gets very ill and dies. you could have wrongful death lawsuits against your company that could be very problematic.
Okay. For a small company with only 4 employees, with only 1 person in the facility at a time, is it acceptable to have employees self-assess COVID symptoms, and what level of documentation is required? Is a temperature check required, or do you have to provide screeners?
Yeah, so a temperature checking is, I wouldn't say is absolutely required. I think it's one tool, and I think it's a very good idea. You know, you can't let someone into the workplace if they have a symptom, but how you determine if they have a symptom, you know, there's a lot of leeway in deciding that. You can go, you know, on one end, some employers are doing very fancy temperature screening at work in tents, and other employers with just a few employees might just have them fill out their own, you know, form about how they're feeling that day and sign it. So, you know, depending on the situation, that might be appropriate documentation.
Okay. Does the employer have to pay for temperature screening if it takes less than 2 minutes?
What do you think, Mike?
I think if you're, well, obviously if they're taking their temperature at home, if that's your requirement, I don't think you have to pay them for that. But I think if you're at the office and they're, you know, having to wait in line or go through a temperature taking process, I think your safest approach would be to pay them.
Yeah, I don't think saving the money for the 2 minutes would be worth the potential exposure on a wage and hour claim.
I mean, look at the public relations problem associated with that too, right? This horrible employer is making us stand in this line when we just want to get back to work, and they won't even pay us for it. I mean, you're going to be in a very unsympathetic situation as an employer.
You don't want to be on the 5 o'clock news.
No.
Ever. If an employee is not willing or able to meet the requirements of a staggered shift, can they be let go?
Well, sure, that's potentially something you could do, but you want to, you know, look at that very carefully. You don't want some situation where you let someone go really quickly and don't realize that they couldn't do a particular shift because of childcare issues, or they couldn't do a particular shift for some other, really legitimate reason. I think, this is a time when we want to bend over backwards for employees if we can and really help people out. I mean, everyone's in really complicated situations right now. Now, if everybody has the same problem, nobody wants to work the night shift, for example, that's just not going to be doable. But I would say proceed cautiously, get information, work with your employees the best you can.
Agreed completely.
If an employee is already on family medical leave because of an illness not related to COVID and then is quarantined for COVID, are they precluded from receiving the COVID pay?
So they still only get 12 weeks total. So what that new law did is added another reason for taking leave. And it's a little different, of course, because it applies quicker and to smaller workplaces and it's paid, but you don't get extra. So if I already took 3 weeks of FMLA leave because of my a knee replacement, and then I have a parent leave pop up because of COVID, I don't get an extra 12 weeks. I still have only 9 weeks left.
Okay. Salt Lake County Health is taking the position that once a caseworker has sent an employee to quarantine, the employer cannot let the employee return to work without first getting a release letter issued by the health department, even if the employee tests negative. Does the health department have the authority to do that? And what is the penalty if the company lets the negative testing employee come back to work before the health department issues the release?
You want to tackle that, Mike?
Well, so, the first point I think I might consider is, if you can work with what the health department's requiring, it may be smart to do that. I don't think you want to run afoul of the health department during the middle of a pandemic. Whether they have the authority to do that or not, I think we're going to see a lot of, when this is over, and hopefully it'll be soon, we're going to see a lot of contention and litigation exactly about what local government powers are and what they can and cannot do. In terms of an employer's situation, you know, the recommendations from the EEOC, and Christina can correct me if I'm wrong here on this, but the EEOC has been saying, you know, take it easy on getting confirmed doctor notes, because they're all wearing personal protective equipment up there on the front lines battling the virus. And so, you know, that's a bit of a mixed message. And maybe you would want to, if you're running afoul of a health department investigator, you know, maybe you might want to, you know, point out the EEOC guidance to them and try to talk through a solution that's going to work for everybody. I don't know. Those are, it's really hard to be caught between the rock and a hard place of two government agencies telling you two different things to do.
I would say, you know, on the first issue, we won't know what anyone has a right to do, health departments or anyone else, until people bring lawsuits and their final decisions in those. So nobody knows. I think the best thing you can do as an employer is take the most conservative approach. And if a health authority is telling you to do X, then do X.
Okay. Finally, that's the last question. The Zoom meeting will be available on the law school's YouTube page, so you can look at it later. And anyone that emails me at Lori, L-O-R-I, .Nelson, N-E-L-S-O-N, at law.utah.edu, I will send you the slides. One more question just popped up, guys. If you send an employee home because they are symptomatic or have a fever, do you have to pay them?
So if they qualify for the leave, remember one of the qualifying reasons for getting the leave was if you're symptomatic and you're seeking a diagnosis. That's one of the reasons. So yeah, so if you have 500 or less employees and you're not exempted for some reason from that, then they would be entitled to that leave. And remember, document that, and you can get the benefit on your payroll taxes for providing that leave and for that pay.
Well, wonderful. That was our last question. Thank you all for participating. Thank you, Christina and Michael, for putting this together. There's a lot there, and what it seems to me is that it's shifting all the time. So this is something everyone has to just stay on top of.
Well, we're happy to come back every week if you'd like.
Oh, I would love that. Thank you. That's right. Go you. Thank you very much. Thanks to all the people who attended. And again, it will be available on the law school's YouTube page. And if you email me, Lori.Nelson at law.utah.edu, I'll send you the slide. Thanks so much. Bye, everyone.